Good afternoon, everyone, and happy holidays. My name is Mike McKenna, and I appreciate it. This is actually going to be the largest audience that we've ever had for a Cohen Seglias seminar, a webinar, and I appreciate that you're all going to be joining us. Just as a mention, so that you don't need to worry about taking notes or anything else, all of the slides that you're going to see here today, there'll be an email link sent to you at the end of the webinar that will send you and make available all of the slides that you're going to see today, so you don't need to try and take any specific notes. I'll probably repeat that later as more and more people get on. So first I want to go through an introduction. I will present and talk about myself. I'll talk about the history of design build, which I find to be fascinating. We will talk about various design build models. And specifically, we'll talk about something called an EPC, a D-BOM, triple P, and how they differ to a degree, if any, from design build projects. We'll focus on the importance of setting up proper contractual relationships, because this is very significant in design build due to the fact that you could be found to do unlicensed work, which could put you in very, very deep trouble in the eyes of the law. We will talk about how design build is very different from design bid build. One thing we will not do is review case law. The main reason is there is no case law, not in New Jersey or basically any in the United States. And in the United States, we focus on law based upon something called stare decisis. I always like to throw out Latin terms so that people think that I know what I'm talking about. But what it means is that in the United States, we base our decisions on prior precedent and decisions by the courts previous to this, such as Brown v. Board of Education, Roe v. Wade, etc. So in this situation here in design build, there really isn't very much case law other than what does the contract say. So that's a difficulty for me, and being an attorney, in trying to give really good, solid advice to anybody out there as to what happens, other than to say, what does the contract say? Some of you may know me, some of you may not. I grew up in construction working with my dad, went to Manhattan College for engineering, started out as an engineer doing resident engineering and also doing design work, and then decided I would go for my MBA. And during that process, I switched over and was going to law school at night. During that period of time, I also switched over and became a project manager for a large New York construction company. And then in 1980, I joined with this great gentleman by the name of Paul Lewis. And we formed Lewis and McKenna, and we were together for many years, and unfortunately Paul has passed. And I'm currently with Cohen Seglias, and what I do is construction law. I've done construction law cases in probably 25 of the 50 states and some internationally. Today, I'm going to primarily focus in on New Jersey law. And one of the reasons I'm choosing New Jersey law is because it's one of the very few states that actually has some rules that are in play as to design build. One of the things that I find fascinating is the history of these things. And how did we get here, and why are we here, and what's the nature of this? Design build, contrary to a lot of people's perceptions, is not new at all. And it's just in the past they kind of used different names for it, or it had different ways that it proceeded. The most common of which was the term master builder. It is the person that you would go to and you'd say, I want this done, and they would design it and construct it and give you a price to do all of that. That concept of master building can be traced back at least to ancient Greece. Indeed, the Greek word for master builder, as you can see, is very close to the word architect. From that time through the 1900s and into the beginning of the early 1900s, master builders were the way that things were done. Ironically, much of those back at that point were led by an architect and not led by a contractor. And there's reasons that this occurred, and we'll kind of go through them, because it's important to me to kind of understand where this came from. I mean, one of the very famous master builders and architect, of course, was Thomas Jefferson, who went on to be president. Another term that was used very commonly was called a turnkey contract. The real history of this can be traced back to the early 1900s, and there was a decision to issue professional licenses to architects and engineers. While some of you may actually be professional engineers and architects, I personally have the first parts of my license for engineering and the first part of my license for land surveying, but I'm not a PE. That this is not something that goes back all that long. Why did they start to issue professional licenses? Well, the architects and the engineers say we needed to do this because we need to be out there and we need to work for the owner and not work for the master builder, to work for the contractor, because this is the only way that we truly can protect the public health, welfare, and safety. I personally believe that that's a bunch of malarkey. And I think it was just based upon the fact that the architects and the engineers in the early 1900s decided that they'd make more money if they worked for the owners, and also a very important part of this, they would not have the risk that would be associated with issues should there be any problems. So many of you might not know, but here's a quick little quiz, and I'll give you the answer in a few seconds. What was the year that the first professional engineering license was granted, and in what state was it granted? Let alone who was the first licensed professional engineer in the United States? And the answer is 1907. And Wyoming, of all states, was the first one to issue a professional engineering license to a gentleman by the name of Charles Bellamy. It then became more the thing to do, but in New Jersey, the professional licensing of engineers and architects, the law did not come into place until 1937. Another thing was happening about that time, which is the Miller Act. The Miller Act is a federal act that requires that if a contract is over a certain amount, that the contractor needs to post both a performance bond and a payment bond. As many of you who are familiar with suretyship is based upon many times assets. And frankly, architect firms, engineering firms do not have lots of land, do not have major pieces of equipment, etc., so that the net worth of them was such that they would get into the business of being able to get performance and payment bonds, so that the general contractor was the one who started to do this. It was also at about this time that the public bidding laws started to come into play, with the concept of awarding to the lowest responsible bidder based upon contract drawings prepared by licensed professionals. Now, the Miller Act here, I'm talking about in the federal arena, but what happened was virtually every state in the United States, including New Jersey, adopted what they called Little Miller Acts, so that this same requirement came into play if you were contracting with New York, New Jersey, Pennsylvania, and that you would have to have this performance bond and payment bond. And as far as I can see, this is really the licensing, the public bidding laws all came together about the same time that we started to now get into design, bid, build. Indeed, I think it's this concept of awarding to the lowest bidder that really is the reason that design build has not even become more popular. One of the things we'll talk about, though, is that many states want to now go through and start to do design build, and because of the fact that they still want to be able to award to the lowest bidder, they've come up with a hybrid that I believe is a combination of the worst of both design build and design bid build, and is really going to be something that is going to lead to many more problems. And indeed, I am already seeing those problems crop up quite regularly now in my legal practice. This statement, members may not engage in building contracts where compensation, direct or indirect, is derived from profit on labor and materials furnished in the building process, except participating owners. Believe it or not, this was an AIA ethical rule as late as 1977 that specifically said that architects cannot get involved with building contracts where their compensation is dependent upon the profit on the construction project. Now, modern design build models, I think, and this is my opinion and everybody has their opinion, I think that it's grown out of the failing design bid build model. Principally because I think engineers and architects in that model are not at risk. When I first started in the 80s and 90s, it was almost unheard of that if there was a dispute on a project, that the owner would at some point turn to the engineer or the architect and say, okay, I need for you to participate in the resolution of this, even if the issue was plainly as a result of an error or omission of the engineer and architect. And even early into the 2000s, I've seen this, but basically since about 2010, I've seen this reluctance go away. For example, now in cases that I'm bringing against the New Jersey Department of Transportation, it has become the standard, and I mean the standard, that as soon as we bring an action again for a general contractor against the N.J.A.C, they will almost in knee-jerk reaction turn around and bring in the engineer, and then the engineer will turn around and bring in any and all design consultants that are involved to the party and into the litigation, which just makes things that much longer. The problem that I see out there is that in general, longer a project takes, the longer the engineer and the architect gets paid, and that they don't, in design bid build, have a sufficient monetary emphasis to get things done as quickly as possible. And again, I understand I'm saying this from a perspective of a contracting attorney, but that's my look at things from 40 years of being involved in this. There's also something I want to talk about here with regard to this, which is called the first benefit rule. Many of you may not even know this rule or know of its existence, but this is very significant. It's particularly of significance because this rule and this part of the law essentially goes away when we switch from the design bid build model to the design build model. And I'll give you an example. I was called in with regard to a major project in Philadelphia that was a really top of the world museum that had to do with the Constitution and had all this audio animatronics and all these electronic displays. It was quite amazing. I was asked by the people who were building the museum, and I'll just use general numbers. We were told that the HVAC for this project would be about $15 million. As the project went on, there was a realization that more and more HVAC needed to be added, to where in the end there was $40 million worth of HVAC that was put into the project. And they wanted to know is, Mike, can we go after the HVAC engineer for that $25 million in addition? And I told them no. And they said, well, I don't get that. And I said, well, it has to do with the first benefit rule. And if you think about it, what it is if they had hired the world's smartest, greatest HVAC engineer, he or she would have recognized that we needed this $40 million worth of HVAC in the first place, so that the owner isn't entitled to essentially free HVAC because of the negligence. In negligence, you are to be, you're supposed to be compensated for your damages. The first benefit rule is, well, how were you damaged? You needed this $40 million worth of HVAC equipment, and you got the $40 million worth. You never had or could have expected that $15 million could be out there. Now, there could be situations where permutations to this can and do exist, but it's a matter out there that has helped significantly to limit the exposure of engineers if they make a mistake or an error. However, now once we get to design build, that whole concept does not exist, because the contractor who is doing the work has already gone hard dollar. Therefore, if he was originally told it's $15 million worth of work, and now it's $40 million worth of HVAC, the contractor can have a claim back against the engineer, because the contractor has been damaged because he or she based their bid based upon the $15 million. So this greatly changes the exposure for architects and engineers in getting into these types of projects. Indeed, I think it's one of the areas that I have found already in design build that engineers, contractors, everyone really don't understand how the game really has changed for engineers once you go to design build. I remember giving a lecture on design build to the New Jersey Professional Engineers and Construction Group, and I told the engineers in the meeting that the light at the end of the tunnel in design build is a train, and you need to be watching out for it. You need to plan for it. And we will discuss what you can do and what everyone should be doing in this situation as we proceed. It wasn't until 1978 that the AIA allowed architects to participate in design build contracts. And in 1985, the AIA released their first series of design build contracts. And we'll talk about them because, to me, the AIA basic system of design build is one of the truest to what I think is the receipt of all the benefits that design build can bring to the table. In 1993, the term design build was really made famous by the creation of the Design Build Institute of America. The Design Build Institute of America was made in 1993. Contrast that to the AIA, which actually has its roots around 1850, 1860, as an organization for architects to get together. And of course, back then they weren't licensed, something that wouldn't occur until the 1910, 1920, 1930. Why design build? Well, I think that Mr. McKenna sums it up as a project delivery system. Design build may be as old as the pyramids, but its return seems particularly suited to the needs and pressures of our time. Why? Because design build is about getting things done. It's about designers designing and builders building, and owners maybe even smiling. It's about making money and progress at the same time. And I truly think that design build can and does achieve that. But it's not a fail-safe. I think that many owners think that design build means no more change orders. No, it doesn't. One of the projects in the New York metropolitan area that you might be familiar with is the construction of the new Tappan Zee Bridge, a $4 billion design build project. And it was probably as solid a design build project and going through the parameters of having it done in a proper manner. And that project, which eventually was a $4 billion project, still has $800 million or so in claims, is my understanding, that have arisen on that design build project. Why? The simple answer is, well, they wanted something that was different than what they said they wanted when they entered hard dollar with the contracting group, and much the same that in regular contracting, if you contract to do X and now you want to add Y and Z and A and B, well, that design build contract doesn't take you off the hook as an owner for paying that. You still have that responsibility. And I will talk about this because to me, the issue is that it creates a need for an owner who's doing design build to actually be smarter and more intelligent than an owner who does design bid build. Right now, I look at, this is my numbers, this is not anybody's numbers, but kind of Mike's numbers as to what's happening out there. I would still say that about 50% of all work out there is still coming out under the traditional design bid build. And I think the main driving factor for that is that it still gives the ability for an owner to award to the lowest responsible bidder. However, design build is certainly out there. And I'm saying 20%. The Design Build Institute actually says that they think that it has equaled or surpassed traditional design bid build. I don't find that from my practice, and leave it up to you as to what your own personal experiences are. But I find it to be about 20% of the contracts that I run into. And it does seem to be more of a thing in larger contracts as opposed to smaller contracts. Another thing is construction management, and then construction management at risk, making up virtually the 100% of project delivery systems that are out there. There is a newbie out there called Integrated Project Delivery. IPD is another set of initials that you may hear thrown about out there. Some of you might be saying, what in the world is IPD? IPD is a situation where an owner enters into contracts with an architect, engineer, and another separate contract with the general contractor. And the concept is that the three parties now work together in an integrated fashion to come up with the project, so that the engineer architect continues to have a separate contract with the owner and to be responsible for the design of the project, with the commentary from the contractor as how they can do it the most expedient and cost acceptable way, with the concept that once the design is completed, that the contractor will perform the work. Many times these are done as construction management contracts, so that in that original contract, they can have the deal structured with the fee, and then the construction management goes on to just simply plug in the cost for the performance of the work with the fee part of it already negotiated. The issue here is that it's only in design bid build that it lends itself to the concept of awarding to the lowest responsible bidder. To me, all of the other systems, other than we'll talk about some of the bastardized design build systems that are currently being used, to require an owner to make a decision as to who's going to be the low bidder based upon factors other than what is the lowest dollar amount. And one of the problems that I still see looming in the background is a continuing concern that owners have, particularly public owners, that if they allow factors other than purely who has the lowest price to come in there, that favoritism may become an issue for public bidding, which they don't want to occur. Design build relationships. It's not a joint venture, and one of the things that I'm going to focus on, and if you take nothing away from this webinar today, I want you to understand need for proper licensing. Years ago, IBM hired my firm. They wanted to look at doing essentially design build in all 50 states. They wanted to be able to approach an owner and say, hey, contract with us. We will build the special room to house your computers. We will then build everything. We will furnish the computers. And to a degree, we will operate and maintain those computers for us. Somewhat of a model that is really design, build, operate, maintain, which is called DBOM, is the initials that are sometimes used for it. So we went and started to do this and looking at it and approached IBM and said, well, you have to understand that it's not that simple, and that if there's 50 states, to a degree, there's 50 different ways that you need to look at what's going to be happening here. And the most important part is that there really isn't a lot of guidance out there in most of the states. New Jersey has guidance, and we'll go through it, and it's part of this presentation, and to a degree I may not even get to it, but the slides will be there for you, to where they've set up the requirements as to how you go about properly doing a design build project. Proper licensing is important, because if you are not properly licensed and you are found to be doing the unlicensed practice of architecture or engineering, the fact of the matter is you do not exist in the eyes of the law. If you have a problem, the courts cannot and will not help you not in quantum merit, equitable relief, or whatever, that if you are not properly licensed, you do not exist in the eyes of the law. Therefore, the courts cannot help you, and you will be entitled to no relief. Well, what do you mean by that, Mike? And there's a case I cite here that I was going to talk about later, but this is probably a very good example of it. An engineer entered into a contract with a contractor to do engineering of a foundation system in New Jersey. He happened to be a New York licensed professional engineer. He then performed the work, got into a payment dispute, and the contractor refused to pay him. The engineer then brought his contract to New Jersey and started a lawsuit against the contractor. The contractor moved for a summary judgment based upon the fact that the engineer was not licensed to do engineering in the state of New Jersey. The court threw out the engineer's case, saying that he was not properly licensed in New Jersey. And to add insult to injury, New Jersey then put a civil fine on him that he had to pay because he had practiced the unlicensed engineering in the state of New Jersey. So you talk about having a bad day. That's a bad day. One of the things that owners need to understand is timeline differences, and this can be looked at in two different ways. There's no question to me, design build is a much quicker way to perform the work because you do have the ability to get certain parts of the work done prior to everything being finalized. Specifically, many times the foundations work, which can be critical, time-consuming work, can be completed before the final structure is done in every nuance. But the owners need to understand timeline differences also has to do with the owner themselves, in that I think to do design build, the owner needs to be smarter. This is because the owner has to make decisions and to let out the contract sooner than their norm. Typically, if you're doing design, bid, build, the owner gets to take a look at the 10% drawings, the 30% drawings, the 50% drawings, the 90% drawings, the complete drawings, and during that process to make tweaks and changes all along that process so that the project, as it goes out to bid, is indeed the project that they want. In doing design build, which can be done with 1% drawings, for example, on the Tappan Zee Bridge, which I talked about earlier, the New York State Thruway gave to the teams that went to do the initial design build conceptual work 4 drawings. The first drawing was, we want the bridge here. The second drawing was, this is the height that we want. The third drawing was, this is the lanes configuration that we want to have. And I said 4. I think there were only 3. Those were the 3 drawings that they gave to the contracting teams for them to go out to do their concepts on. Not much, but we'll talk about it later, how that process went through. In design, bid, build, everyone listening to this is familiar with the way this sets up as to the owner, the architect, design, QA, QC, being on the side typically of the owner's team. It sometimes can be a joint process. Construction manager, design build, we have the owner and construction manager on one side, and now the architect and the engineer is part of the contractors team. Important in noticing this is that this is a very major change for sureties, because now not only the sureties guaranteeing the performance of the contractor in giving a performance bond, but they're also guaranteeing the performance of the architect and the engineer. So that this has caused concerns and issues for sureties as to how are they going to be looking at this new design build team and the risk that they have with regard to performance bonds. The owner's team. Well, the first responsibility that the owner has to do is to figure out what do they want done. Commonly, this is done through a scope book. The scope book being a document that defines the general nature of the work to be performed. I found commonly another way to do this is for the owner to come up with a 30% design. And I don't know why 30% has become the commonplace, but it has, from my experience, is that there is a preliminary design and that the owner then puts out that 30% design to contractors for them to have their team take a look at it and to come up with a price to complete the 30% design. And then the owner typically will enter into negotiations with the contracting team to come up with a price. The issue to a degree is that this is now being used by public owners, except now that 30% design is being used to come up with a lowest responsible bidder. And I just see that there's going to be a lot of problems with that type of procurement system. As in anything, basic contracts 101, the more specific you can be as an owner, the more likely you're going to have a good outcome. The looser that you become to a degree, the more exposure you have for there to be differences. You also need to think in doing this, you need to define needs such as how much time, if there's going to be any milestones out there. But the most major decision an owner has to do is how much design am I going to do? Knowing that the more design you do, the owner therefore will have more responsibility or liability for that design should it cause issues. But at the same time, it gives the owner more time to determine exactly what they want or what they need. Again, whether they're going to have some sort of construction manager, consultant, someone working with them, is up to the owners. The contractors team. One of the questions you need to ask now that you have architects and engineers working for your team is there any special insurance requirements you need to have? I think that the simple answer is yes, because now the engineer and the architect is working for you. Engineers and architects, there is no question, design build creates a much larger risk for you as to financial and legal issues that you need to be very smart in the way that you're setting up your business model, particularly in an area of errors and omissions. Typically, contracts are set up with the contractor's ability to rely upon a design put forth by the engineer or the architect. I was involved in a project where the contractor was doing a large bridge project in New Jersey. The engineer gave the contractor a foundation design, and the contractor then worked up their price. The contractor's contract with the engineer specifically said, however, if that design turns out to be wrong, that the contractor has the ability to come after the engineer for any additional cost or time related to that error. Well, as it turned out, the engineer did their design in a manner that they made a major mistake as to what were going to be the loads. The contract documents told the contractor and the engineer to design the bridge so that it could withstand an impact from a barge traveling at a certain speed and carrying a certain number of barrels of fuel in the barge. For whatever reason, the engineer thought there were 40 gallons of fuel in a barrel instead of 55. As a result, the computations as to that impact load were way low, and the size and complexity of the foundation increased dramatically. But to show you what can happen, and happened here, was at that point the engineer decided they were going to get a consultant involved to take a look at the design. They hired the number one impact design consultant, who took a look at the criteria about the barge traveling at such a speed, carrying so many barrels of oil, and basically said, "Who told you this? This is not what the proper impact criteria," and said, "This is the way you need to do it." So that foundation that was originally X, and I'll just use general numbers, because of the engineer's X problem, went from X to 2X. However, now when you took into account the proper criteria, the foundation now went to 5X. So the contractor said, "Okay, owner, your responsibility is for 3X, and engineer, your responsibility is for 1X. And the whole contract blew up. There was a termination for convenience, and the owner decided to go a different way with the project, and it just got to be a very big to-do. But it kind of shows you that even in design build, issues can and do come to the table. The major issue for a contractor or the engineer or architect is, what if there's a problem? Who's going to pay? The fact of the matter is, the net worth of most architects and engineers, and I don't mean this in any type of derogatory fashion, it's just that's the way it is not very high. Therefore, the problem can only realistically be covered by an errors and omission policy. To state the obvious, you can't get a performance bond from an engineer or an architect. However, in doing this, you need to know that there's a lot of idiosyncrasies with regard to coverage, and some of you may not even know what a tail policy is, but I'll just kind of briefly touch on these. And I can see based upon the time that I'm not going to get through all of my slides, but the important part is up here at the beginning anyway, and the rest of it will be there and is much more self-explanatory. Errors and omission coverage is somewhat of a unique animal in that it's almost always what they call a claims-made policy. So let's say in 2020, you enter into a contract with an engineer. The engineer completes their design in 2020. In the year 2020, when they do that design, because of this, you as a contractor make sure that they have a $50 million E&O coverage for that year. Now, in 2022, the contractor is out doing the work and discovers there is an error in the design. However, in 2022, the engineer now only has a $10 million E&O coverage. The contractor will not have the benefit of that $50 million policy, but will instead only have the $10 million policy to go after. That's because these policies are set up on what they're called a claims-made basis. It's the policy that's in effect at the time the claim is made that is responsible for coverage, not the one when the alleged negligence took place. One of the things that's out there to assist in this is to have a tail policy, and a tail policy can be set up where that original $50 million of coverage stays in place for a defined time, typically to 10 years past substantial completion, so that it falls in line with what's called the statute of repose. But the fact is that there is a need to understand this. Plus the fact that one of the things that people don't understand is an E&O coverage. It's also what's known as an eroding policy. That means that if you start out with $10 million of coverage and they spend $2 million in defense of the claim for attorneys and consultants and everything else, the policy is no longer a $10 million policy, it's an $8 million policy. That the amount of the policy erodes based upon any engineering or consulting expense, litigation expense associated with it. As I talked about before, too, one of the new exposures is that in this design build model, there is a major exposure that the engineer is picking up because they no longer have the protection of that first benefit rule. As I said in that other one, if we had gone to the first benefit rule in a situation with that foundation that I talked about, no one would have been able to come after the engineer because the really smart engineer would have recognized, okay, it's going to be a 5X foundation, and therefore neither the owner nor anyone could have come after the engineer for that. However, in this situation, we have that division that comes up because of the whole different setup as to the contracting. Now, again, this is Mike law. There isn't a case that would say, oh, Mike is right. The first benefit rule in a design build situation is not going to be in play, and that what Mike is talking to you about is absolutely correct based upon the case of Jones v. Smith. There are no cases out there that talk about these things. A lot of what I'm telling you is just me and 40 years of experience and dealing with 40 years of judges and court cases and what I believe will be the situation, not what I know will be the situation. One of the areas that I've been surprised from my experience where there's been really not that much of an issue is with regard to subcontractors in design build, and somehow that hasn't been based upon the 40, 50 design build litigation cases that I've gotten involved with. That hasn't been an issue. The surety, though, as I said, has a whole different animal here because the surety's obligations run to the owner or the obligee, our fancy term, and don't run to the contractor, and they are bonding the performance and payment. Normally, the surety is determining how much to charge for a premium and what the contractor's ability to get bonding based upon the track record of the company, including such things as annual revenue and net worth, etc. Many times it's secured with personal indemnification from the construction company's officers and spouses under a document referred to as a general indemnity agreement. Now, with the design build, the surety is also guaranteeing the performance of the architect or the engineer's work. So this is a different animal for them. It's, to me, a whole new ball game, and they will, of course, not have personal guarantees from the engineer and the architect, but also they will have personal guarantees from the contractors, principals, and spouses. So to a degree, it's an exposure that they're picking up in design build that they don't have in the design bid build model. Again, the issue as to what happens if there is a major boo-boo by the engineer or the architect, and this is where the experience as to engineering and E&O policies come into play. New Jersey, and I'm starting to get closer to the end here of this 1 hour, and unfortunately I could go on for an extended period of time talking about this, but then again, you might not want that. But New Jersey is one of the only states that has an administrative code that really starts to look at this. Granted, they only look at it from the eyes of the architects. Why the engineers in New Jersey do not have similar administrative codes baffle me as to why the architects were smart enough to be able to put these administrative codes into place and the engineers have not. What I've told engineers and will continue to tell them is behave as if the administrative code applies to you, because I think it makes common sense and will give you some level of protection. This administrative code has to do with how our projects bid in New Jersey. And I happen to take here the one for the New Jersey Transit, which is very similar to the one from the New Jersey Department of Transportation. Here it says the award shall be made to the lowest responsible bidder. However, this provision shall not apply to design build or design build, maintain, and operate projects. Unfortunately, though, they have tried to make it apply in those situations, which to me has led to issues. The one case here is a case where a mechanical engineering company came after the New Jersey Schools Development Authority, N.J.A.C, and wanted to have the courts find that design build was illegal in the state of New Jersey. And the court said, no, it's not. The statutes are proper and that this is a valid way to proceed. But it's really about the only case that I've come across that's out there that starts to deal with these issues. The AIA system is here, and it sets up one model. And I see that I'm starting to really get close to my time here. So I'll just kind of go through design build models. This one, the AIA system, usually starts out with a bare minimum of input from the owner. And as I said, the Tappan Zee Bridge was 3 or 4 plan sheets. What happens is those 3 or 4 plan sheets are given out and bidding teams are chosen. Typically, the bidding teams are somewhat vetted by the owner prior to going out and doing the project. Certainly, this is the model that's used in many of the large projects. Typically, there'd be 3 to 5 teams. In each situation, each team comes up with its own presentation based upon those plan sheets as to how the work will proceed. And each of the 3-5 teams is paid a stipend for having to do that. The owner then looks at each one of the teams, meets with them, and decides what they like best as to concept and price, and not necessarily giving it to whoever has the lowest price. The Owner also has the ability, because they're paying for these designs to utilize, and part of the agreement is that they can take or borrow things that they like from other teams' concepts and utilize them in the final project. The owner then enters into a hard dollar contract with the single team. Engineer, procure, and construct. To me, 6 of one, half a dozen of the other. I don't see where EPC is any different, other than the fact that very typically EPC has a 30% drawing. I say, although nothing in this area is typical, I cannot stress that enough. If you are entering into a design build contract, look at the terms, look at the conditions. As I said, I've been involved with probably 40, 50 cases which have gotten into issues and gotten into some sort of claim situation. I don't think that there have been 2 of them that have been the exact same type of contractual setup. You need to understand what you're getting into and what's going on. That in this 30% design drawing, which, as I said, has become somewhat of a norm, but nothing is normal, that it also now creates a responsibility. Well, what if that 30% design drawing is wrong? I talked about the problem with the bridge before, and the contractor looking for the 3X there. This is indeed the area that is going to be greatly contested. And as I said, one of my issues is that we don't have the issues as to what is going to be the case law. We don't know. And I see I have one question here, and I'll try and answer it, particularly because the asker is probably one of the leading construction mediators, and I can highly recommend that if you ever have a construction mediation issue and you want one of the best, you want to reach out to Howard Benzie. And Howard wanted to know and have me explain the first benefit rule again. The first benefit rule is the concept, okay, that an architect goes out and puts out a set of plans and doesn't put windows in the building. Yes, the architect committed negligence. The fact of the matter is, your building, however, needed windows. If you'd hired the world's most competent architect, they would have put windows into your specifications and you would not have had to pay extra for them. But the fact of the matter is, you still needed the windows. So you, as the first benefit, don't get free windows. That situation, however, doesn't occur in the design build model, where you're now going to have exposure to the engineer for the cost of those windows if they make that mistake. Now, my time is up. I thank all of you who attended, and I appreciate it. Again, we will be sending out these slides, and hopefully you'll find this to have been of some assistance to you as you go out and deal with design build. I think that you're going to need to look at the contracts, look at what your responsibilities are, and understand that there really is a lot out there that is yet to be determined. Thank you very much.